So that lenders can visualize what we're saying a bit clearer. And as an example, if we had a client who are looking to fund a purchase of a recently completed residential block, which is 19 meters tall, what is it that they need to be thinking about?
The first question is whether the borrower has complied with their obligations in relation to fire safety. So, is the golden thread complete? Has the building been registered? Has final approval from the building safety regulator been received? Is the safety case up to date? All these kinds of key questions. This is a new and highly specialised area of due diligence, and the lender will need to think about the team that they appoint to support with this. They're likely to consider appointing a fire engineer to review the technical documents and potentially also inspect the building. And then in terms of the legal elements, Womble Bond Dickinson can support with additional due diligence. It may be the case that the borrower is doing their own due diligence, in which case the lender should have reliance in relation to this. But again, Womble Bond Dickinson can review this for you to make sure it goes far enough.
Thanks, Sarah. And so it all comes round ultimately to the question of what happens if the borrower doesn't comply with these obligations under the Building Safety Act. And I suppose what that breaks down to asking what are the risks to the borrowers and what are the risks to the lenders?
Yeah, I mean, in terms of the borrower, let's perhaps start with them. Fines and in some cases imprisonment is the short answer. For breach of building regulations, the Act is saying it's now up to 2 years imprisonment, plus personal liability for directors or senior managers. And the same goes for breach of the PAP or AP duties in terms of length of potential imprisonment and personal liability. Also, importantly, if the borrower is obliged to but has not carried out any remedial works obligations, there is the possibility that there will be civil claims against the borrower pending or on foot in terms of claims under the Defective Premises Act, which has extended limitation periods now of 15 years and 30 years in some circumstances retrospectively. And also exposure to claims for remedial orders requiring the borrowers to carry out the work, or remedial contribution orders requiring them to contribute to the costs of remedial work, and possibly also what are called building liability orders, which is where somebody is seeking to make a claim and is tracing company ownership through associated companies, which could also be potential exposure there as well.
Yeah, so from the lender's perspective, there are three real scenarios that we need to be concerned about. The first is a breach that's arisen but can be dealt with and separately resolved. So as we've said before, in relation to the golden thread, the lender will need to ensure that the borrower complies with the requirements or the works to ensure ongoing compliance. It's far less damaging for all parties if a breach is remedied quickly and efficiently than allowing any sort of formal enforcement to take place. Again, as I've mentioned before, it must be remembered that these are not costs that can easily be passed on to leaseholders. Any costs that are recovered will be capped. And so this is something that they might come to a lender for more assistance on, either from you as further funds, equity injection from the shareholders, or third party or mezzanine finance. The second scenario is a breach that's unresolved or has been subject to a formal enforcement. As Simon said, the borrower is potentially subject to fines and personal liability imprisonment. As a lender, this could impact the cash flow if it's a large fine, or if imprisonment, obviously the borrower's decision-making ability is impaired. Another issue to consider is whether or not a breach by one company can affect the potential liability of a group. So that's a topic all by itself and not one that we can cover here. But the point is that there's a potential risk across the portfolio that other obligors could be called upon for a different group company breach. It's therefore vital, as we mentioned a moment ago, to ensure that these breaches do not go unresolved or allowing formal enforcement to take place across any building in the portfolio. And then a third scenario, an area of risk, is that there's a risk of the general impact on the value of a non-compliant building, and so its impact on financial covenants, so loan to value covenants, for example. If the value decreases because of any difficulty in marketing a non-compliant building, there could be a future breach of these financial covenants. So these need to be monitored, and potentially additional conversations to be had with a borrower around the structure of the loan. If you then have to enforce your security against a building with any unremedied breaches, you are likely to face a situation where the value is not necessarily the market value, and so you could be looking at a situation where you've crystallized your loss on that loan.